Wait,
Yes.
I would like to mention item number 26. Here, my lord, I'm led by London Senior Counsel A. Bora. He has not been able to come. It will be taken after 3 weeks.
Okay. Heard Mr. D. Pangin, learned counsel for the appellant, who has prayed for adjournment of the matter. You just make it like that. Okay. In view of the book list after 3 weeks.
Item number 28 also, my lord. I have taken counsel.
Okay, same?
Yes, I have for a respondent.
Okay. Who is for the appellant?
Mr. Boja, I have informed him. In fact, he was
Okay.
supposed to send somebody, but
Okay, okay, so just make it land council, Mr. So-and-so for the respondent with the consent. Okay, okay. Adjournment 3 weeks.
Your lordship, may I beg to mention item number 5. Item number 5.
What?
My lord, could it be taken up on Monday, ma'am? The reason is the leading counsel PD9
Okay,
could not come to the lordship.
okay, those adjournments, I thought it will wait for their turn. We will only take up supplementary hearing, which is likely to take long. Okay, if those are then rest to wait for your turn to come up.
Right.
Let's see the stage also.
Right.
Hearings, though, no stage is required, just adjournment.
My lord, I beg to mention item number 29
Huh.
on behalf of K lawyer.
Okay, mention is
consent,
made on
yes,
behalf of
yes.
K lawyer, learned counsel for the appellant for adjournment of the matter with the consent of the respondents. List after
3 weeks.
3 weeks.
Much obliged. May my ladyship, I beg to mention item number 8 on behalf
See,
of SK Theory.
These items which are not tested for supplementary hearing,
Yes.
I'd like to see what are the required steps in the matter. Okay,
Sir.
so we will just simply adjourn the supplementary hearings and the rest you wait for your turn. It will not take long.
My ladyship, actually, he could not make it. SK Theory. Today morning only I got a telephonic call stating
So
that.
we'll see what is the stage, what are the steps required to be taken, and then we'll adjourn. Okay, because the
obliged.
opposite will also be there. But supplementary hearings, we can simply adjourn. It's not difficult.
My ladyship, consent has been taken from the other
But,
council.
but what is the step to be taken? Tell me what is the step, required step?
And that if I'm unaware.
Then we'll see, we'll open the file and see. So you please wait,
Okay.
okay, for your turn. We will open the file, see, and then we'll adjourn.
Deeply
Okay?
obliged. Your lordship, I would like to mention item number 30.
30.
Yes. Leading counsel B. Arun is engaged in his late mother's death anniversary. So I would like to request court
Okay,
to
for
give
the
any other.
appellant.
Yes, ma'am.
Submission is made for the appellant.
Yes, sir.
Okay, on behalf of the leading counsel for the appellant for adjournment of the matter with the consent, have you taken of the respondents? Consent
yes.
taken, list again, 3 weeks.
Thank you.
May I, my lord? My lord, I beg to mention item number 27, my lord. I'm for the respondent, my lord, on behalf of opposing party, my lord. And I have taken consent from the petitioner, my lord.
Okay, same order with the consent of the petitioners. Okay, mention is your good name?
Teaming, my lord.
Okay, Mr. So-and-so makes mention on behalf of Mr. O. Pandey, learned counsel for the respondent. Okay,
And madam, the list after 4 weeks, my lord.
list after 4 weeks. Same order, Yes.
Your Honor, I would like to mention item number 28 as my senior counsel is out of
20?
28.
28, we have already adjourned. All supplementary hearings have been adjourned.
Okay, thank you, ma'am.
May I beg to mention one pending matter, this land compensation matter may be fixed for tomorrow.
What's the urgency?
Urgency for
Let it come in its turn.
Release of the
What happened?
release of the compensation bill. Compensation is going to be released and there is no interim order.
Okay,
Matter may be exempt.
for tomorrow.
I would like to mention one unlisted matter. This is criminal revision petition. That revisionist is in the jail. So this is urgent matter.
How can
So,
it be?
this
Is
matter may be listed-
convicted under which section?
Pardon?
Conviction is under which section?
Conviction, conviction is for 3 months for false FIR. Informant has been
Under what
convicted.
section? Under which section?
This is section 22, clause 2 of the POCSO. POCSO Act.
Okay,
God bless.
but this is a criminal matter. Criminal matter usually goes to the more junior bench, okay?
I have, recently I went there,
Uh-huh.
but the court number 2 asked me to mention before the court number 1.
But you can list it before court number 2. Pardon? Listen,
Wait, please, Lord.
tomorrow or they on Monday? Whatever.
Lordship, I beg to mention item number 10.
Okay, you listed before this court, it's okay. Yes,
Lordship, I beg to mention item number 10.
why? What's the stage? What is the stage?
Order.
What is supposed to happen in the matter?
Lordship, deponent is out of station, so we need to file affidavit in reply. So we need some more time.
Is it? We'll see the file. You wait for some time. Okay. Yes.
May it please your lordship. Lordship, this is an anticipatory bail application, lordship. Under section 438 CRPC, lordship. An FIR has been lodged on 2/12/2023 under section 354A IPC, lordship. So when accordingly the police sent me a notice under 41A, lordship, and I could not comply with the notice, lordship, and I have given reply also to the general election also. So now I am trying to comply with the police, lordship, for proper
comply.
adjudication.
At the outset, your lordship, my submission would be this petition is not maintainable because 354A is a bailable offense, your lordship.
Is it?
Yes, your
Let's see. If it's bailable, then you apply
Yes.
for bail.
your lordship
Yes,
Why
may,
have you come for anticipatory? Let's see, IPC.
the case is registered under section 354A only, your lordship,
354.
solely on 354A. And it's
CRPC.
Schedule 1 part 1.
Sexual harassment.
Yes,
Punishment
your
is-
lordship, sexual harassment of the nature of
So
unwelcome.
it's a bailable offense.
But lordship, my prayer is, lordship, the corresponding sections of BNS, lordship, which is under section 75, this is,
That
lordship,
has already been
non-bailable,
settled, your lordship.
That it is non-bailable.
When did the
lordship,
incident
therefore,
take place? When did the incident take place?
that is prior, lordship, in the year 2023.
Prior, then leave it. Heard Mr. So-and-so, learned counsel for the applicant, along with Mr. Ikhtiar Learned, additional PP for the state respondent. It is seen that the application for pre-arrest bail filed under section 438 CRPC is for an offense alleged to be committed by the applicant under section 354A IPC. The learned additional PP has brought to the notice of the court that section 354A IPC is a bailable offense. In view of the above, this court, finding that the offense is bailable, dismisses the instant bail application 102 within brackets A of 2024. Yes.
May it
The
please your
incident
lordship.
occurred before July, okay,
Yes,
before the month of July 2024. And therefore, the IPC will apply. IPC is applicable. And then
Lordship, that observation may be given, Lordship, because
I've
there are
passed
so
the
many.
order,
qualities.
I've passed the order.
Your Lordship, on last earlier occasion, it has
Yes,
already
yes.
been settled by this honorable court. What section will be applicable in CRPC will be applicable. Your Lordship.
Regarding whether IPC is applicable or not, you please look at, I've seen the order, look at this court's order dated 19/07/2024. Okay,
Yes.
yes, previous court date.
Deeply obliged. Your Lordship.
Your Lordship,
Yes.
may I? Lordship, this is a joint petition for quashing of the FIR. The facts leading to this petition, Your Lordship, is that on
What
14th
is the
and
charge under, in the FIR?
380 IPC.
380 theft.
Yes, yes.
So theft, what happens? Theft is theft. Did you
Yes, Your Honor.
steal something?
But the incident which occurred, Your Lordship, is that the petitioner number 1 and 2, who were accused in the trial court, they entered into the shop of the petition number 3.
Okay, I will issue notice.
Lordship, and Lordship, scan copy of the answer may be called for.
Let's see, I heard Mr.
Taja.
So and so learned counsel for the applicant, for the petitioner who has filed this instant petition for under section for this court to invoke its inherent powers under section 482 of the Criminal Procedure Code for quashing the FIR dated 14/10/2024. Registered as Chimpu PS case number 61/2023 under section 380/34 IPC and the corresponding GR case 844/2023 pending trial in the Court of Chief Judicial Magistrate, UP. You see, coming for every small little thing
Your
to
Lordship.
the court for invoking its powers under 482, you should take note that it is only on rare and special occasions that the court wants to interfere in those little things. Okay, anyways, we'll see your case. Issue notice to the state respondent. Miss So-and-so accepts, learned, additional EP accepts notice on behalf of the state respondent. List,
Your Lordship, kindly the proceeding may be stayed for the proceeding till the dismissal.
no. List after 1 week. In the meantime, CR is a scanned copy of the charge sheet has been framed? No.
Not yet.
A scanned copy of, no, in the meantime, CD is to be called for. Yes. His diary, isn't it?
This is GR case, has
GR
already
case.
been filed. Lordship.
Okay, nothing.
The Scan
be
copy
filed.
of the LCR, Lordship, try for
Okay, in
record.
the
Lordship.
meantime, scanned copy of the LCR is to be called for.
Your Lordship, kindly the proceeding may be stayed. The
380, leave it.
Your Lordship, kindly let me be stayed.
No, then the whole, this thing will be, we'll list the next week.
Because Your Lordship, the next date is 6/30th of this month. So I pray that the proceeding may kindly be stayed till the disposal of this case.
No.
That because the parties have already entered into agreement, and moreover, the thing that was
See, the complainants also can appear before the court. This is, if you say it's a small matter,
yes,
what is, then, the court is also there. We have to have some faith in the concerned lower court, that they will also exercise their jurisdiction and their, what common sense concerning this case. We don't have to interfere in everything. So let them appear, they'll appear before the court will also see what is going on, isn't it? Have some faith in the lower court,
Yeah,
they're very good.
that case,
Okay.
Your Lordship. At least I pray that it will be listed before 30th of this month.
So what will happen? Nothing will happen.
Then I pray that the matter will be listed on 29th of this month, Your Lordship.
What?
The matter will be listed on 29th.
So let it be listed.
On 29th of this month.
It's not that as if I'm going to grant your prayer straight away also. Okay, let them go. What's wrong with that?
Your Lordship,
They don't have to be scared. The court is there. Okay, lower court have faith in the lower court. If you say it's a simple matter, you can explain the matter to the lower court also. They will use their jurisdiction, minds, common sense and see.
Your Lordship, kindly then please 29 and 29. Your Lordship. If this court is not inclined to stay the proceeding, at least your Lordship,
What is going to happen to them if they appear? They don't want to appear. Where are they?
they have in other district, Your Honor, and they are
Huh.
students, Your Honor, pursuing their
Huh.
career. So coming to the court from far away places may hamper the, because they are not criminals, Your Lordship. So the act has been done just in their innocence and their,
So appearing before the court doesn't mean they are considered criminals
That is
straight
true.
away. They are not criminals. They
But
are
difficulty-
considered, so the court will also consider them to be innocent.
that is true.
The court will also consider the fact that they are students, okay, lower court.
Despite that, Your Lordship, I pray that kindly the interim may be granted to me.
Have you made that prayer in
Yes.
your?
Yes, Your Lordship, I have made.
I don't know why you're not having faith in the learned law courts. They will appear, the court will take care of them. What had they stolen?
Mobile.
Mobile, stealing a mobile phone is very, very irritating. Everything is gone for the person who is the owner of the mobile. It's not a small matter.
Your Lordship, the stealing from inside the house is a different thing. But in my case, Your Lordship, it was just lying in a counter, which they picked it up, not when inside the house and stealing. That is a different thing, Your Lordship.
The learned counsel for the petitioner further submits that the proceedings before the learned lower court may be stayed till the next date, since the applicants are students, is it?
Yes, Your Lordship.
Residing, where they're residing, in which village?
This Yomcha village, Soin village, Basar.
Residing at so-and-so village. And it would be difficult for them to appear before the learned trial court, wherein the next date of appearance has been fixed on
30 July.
37/20/24. Since the applicants are students of which class? Of which,
College,
what? BA?
BA.
Students, BA, students of BA at which college?
This one is at Pasigat, the other I'm not aware of.
At Pasigat. Considering the nature of submission made by the learned counsel, the proceedings before the learned court, which court?
CJM UPA.
CJM
UPA.
UPA.
Yes.
UPA in what is the criminal case number?
GR case number.
In GR case number 844/2023 is to be stayed till the next date of listing.
Thank you,
List
Lordship.
after.
I'm obliged.
Yes.
This is the petition for question of FIR bearing number 74/2024 dated 15/7 July of 2024 under section 420 registered at PS Nahar, Logon. In nutshell, the petitioner is running the business of trade or of commercial kitchen equipments. Respondent number 2, that is the complainant, ordered him to prepare.
Under which sections?
Nothing. Only 420.
Pardon?
FIR is my
420.
420. It's a simple business transaction.
Okay, you're saying that it's of a civil nature,
Yes, ma'am.
business. Okay.
Lordship,
Kindly
Lordship,
see
may
FIR
see, Lordship,
and-
it is registered on 15/7, Lordship. So it will govern, Lordship, under BNSS also, Lordship, because Lordship, recently, Lordship.
Yes,
Delhi-
yes.
Lordship.
So this is after 1st July.
Yes.
Okay. So what is I think the new laws will be applicable in this case.
I don't think so.
The learned counsel for the petitioner submits that he may be allowed to withdraw the instant petition with a permission to file afresh.
My lord, FIR in the section registered under 420.
On
IPC.
Lordship, but it is
Ah,
registered of
so they
15
have done it wrong. You should use the new laws.
15 July, no?
See, the incident happened on 15/07/2024. Okay,
It's
so I don't think you associate this confusion is there, but when the incident happens after the
no.
so even your prayer,
There is no cause of action. The respondent number 2, that is the complainant, ordered.
but the application itself, it
Yes.
should be under the new law.
No, so it will
5 to
531 Lordship, bit Lordship, 482 Lordship.
Pardon?
482 CIPC bit 531 Lordship, because recently the Delhi High Court Lordship had made the observation that Lordship.
Yes, this confusion is there,
Lordship.
but what is clear is if the incident happens after 1st July.
Read bit
2024.
Lordship, it should be Lordship 482 CIPC, read bit 528 of BNSS Lordship.
520. Yes.
Lordship.
So make the corrections,
Lordship, it is
you make your corrections
We are
and then submit
Delhi
it
and-
again.
Lordship, moreover, this is
unable to stay here. In my,
But then you
document.
should have been aware. What do
But
we
my
do?
lord, there is no cause of action. Registered.
Yes, so we'll have to see whether there's cause of action or not.
Only
That
से
is your
registered किया
submission.
420. मैं तो उसको
Lordship.
FIR को ही bed in law.
Yes,
This
then
is-
you should not worry.
Lordship.
FIR itself, let the FIR be there during the investigation. They will be discharged.
Kindly see the content of the FIR.
Lordship, they have the
There is
every
nothing
Lordship,
to any-
they can come under Lordship, anticipatory bail also, if they have apprehension of arrest Lordship.
There
They
is no
cannot quash
there-
simply the FIR Lordship, they
only
cannot
two
enter
factors
the
of complaint.
investigation.
Then you tell your client to engage a counsel who is from this the locality, then your problem will be solved. Okay. Yes. I heard Mr. So-and-so, learned counsel for the petitioner. You make the corrections, be aware, we can't do everything for you, isn't it? Along with Ms. So-and-so, learned additional PP for the state respondents. You're going to pray for withdrawal, then you submit the correct one, isn't it? It is seen that the instant application, the instant petition has been filed under section 482 Code of Criminal Procedure Code, seeking quashing of the FIR bearing number 74/2024, which is dated 15/07/2024.
Honorable court can consider it's under section 5 to 8 in new laws.
In view of the above, this court finds that it would be more appropriate if the instant application is made, instant petition is filed under the appropriate new laws, which is enforced at the time when the incident was said to have, at the time when the FIR was filed. Accordingly, the learned counsel for the petition is allowed to withdraw the instant petition and make the necessary changes. Okay.
Yes.
And file afresh as per law. Yes.
Apply to-
Criminal petition stands dismissed as above. Yes.
Your Honor, kindly pass over item number 4 and 5 for some time. The senior counsel is currently engaged in court number 2,
Okay, yes,
4 and 5.
Pass
Item
over.
4 and 5.
time being matter. Oh.
Much obliged.
Yes, I'm well.
Yes,
My lord, in this case, my lord, today, my lord, substantial question of law need to be framed, my lord. Substantial question,
pardon?
today, my lord,
You want to pray for adjournment?
No, my lord, I am for the petitioner, my lord.
So,
Appellant. Today, in this case, my lord, substantial question of law, my lord, need to be framed, my lord.
yes, yes,
But,
okay, substantial questions of law have to be framed, huh?
Now,
Counsel for the respondent is not there.
not my lord, they did not appear, but those services have been complete, my
Okay,
lord.
what are the proposed substantial questions of law? Have you laid them out in your?
For that, my lord, I believe, my lord, that will take some time, my lord.
Okay, so.
May I pray that this will be listed after 1 week, my lord?
Okay, heard Mr. So-and-so, learned counsel for the petitioner who has prayed for adjournment of the matter. In view of the above, list after
1 week.
1 week.
I love it.
Yes, in item number 7, affidavit in opposition.
They haven't filed till now.
Last chance. It was for the. Yes, Mr. M. Kato. Now, this court's last order was that Mr. M. Kato, learned deputy SGI, submits that they will be able to file their affidavit in opposition by the next court date. But Mr. Kato is absent. Yes, Miss
Sonam Somu.
so-and-so, learned counsel for the petitioner is present while none appears for the respondents. In view of the above, list after 2 weeks.
My lord, that item number 5,
Hmm.
I'm told it is possible for the timing,
Hmm.
right? My lord, here, my lord, the matter has been again re-put up to the high power committee, my lord, with some modification. So now entire matter is before the pay anomaly committee, my lord.
Let's see what is item number 5.
This matter is pertaining to pay scale, my lord, of the research cum librarian of the Guwahati High Court.
Okay, the one which we have been taken up through
Through-
video conference.
Yes, absolutely, yes, you are right, madam.
Okay, that case. Hmm.
My lord, latest affidavit filed by the finance department. It says, my lord, the matter has been placed before the high power committee for consideration. Ma'am.
High power committee.
Yes, that is pay anomaly committee, my lord.
But how long will that take? Because what we had observed in the last court dates was that the affidavits filed by the state respondents did not indicate whether the state respondents were going to consider the representation made by the petitioner favorably or not.
My lord, that's why, my lord, the matter has been placed before the high power committee, that is pay anomaly committee. Any discrepancy in pay, my lord, issue, my lord, that has been placed before the pay anomaly
Okay.
committee, my lord. Since the matter is pay scale, my lord.
Okay, fine.
But may I, Lordship?
Hmm.
As per the order dated 5/6/2024, Your Lordship.
But,
It says, may I read, Lordship?
uh,
5/6/2024. In the third paragraph.
5,
5/6/2024. Order that.
yes, you said, what is the order?
Your Lordship's order.
5, 6,
24.
yes, but that's
Here,
the
Lordship,
27.
it says like this. In view of the above, further time is granted the state respondent to file their affidavit to make clear the state.
Yes, they stand, that was I
Yes,
was
Lord,
mentioning.
that-
So when it is placed before the high power committee, does it mean that they are thinking of taking positive steps? Does it indicate that the respondents are considering the representation in a more positive manner?
Well,
Can
that's
we
why,
take it that it indicates that way?
yes, my lord. First, the proposal was rejected by the high power committee,
Hmm.
saying, my lord, it's not feasible to give him pay installment with at par with the under
Right,
secretary.
right, right.
The, again, with some modification, again, that in place before the hyper committee. I hope, my lord, this time, my lord, something positive will come out.
Maybe it's been considered in a more positive
Yes,
attitude, maybe.
That's why it was.
Okay,
again,
yes. We will reflect that. Okay, we'll reflect that in the order.
My lord, may not, because it is hyper committee who is to give a final call, my lord, either to accept or not to accept, my lord. Now, it's very difficult to say any assurance before your lordship, my lord.
Okay, heard Mr.
Kebui.
Okay, so and so learned counsel for the petitioner along with Mr. So and so learned senior standing counsel. No, learned, yes.
Additionally, AG, my lord.
Yes, wait, additional AG for the state respondents. Now, anyone appearing for the High Court,
Mr. Mukherjee, my lord, senior advocate, Mr.
Ah.
Mukherjee, my lord.
but no one, okay, okay,
He's
anyway,
absent today.
so and so, okay. Okay, we'll just hear the submission of the additional AG, okay. The learned so and so appearing on the for the state respondents submits that this matter has now been again placed before the high power committee. When? Any idea? No idea. Any idea as to when they are going to have their sitting or anything?
My lord, this latest affidavit filed by the finance department that at 14 June 2024. The paragraph 3 says, my lord, that matter has been placed before the hyper committee and they are waiting for the, my lord, final decision, my lord. Paragraph 3, my lord, is category 6.
As per the information received from the finance department, while the communication dated,
No, my lord, not communication.
Wait, wait,
Affidavit filed by the finance department.
where is affidavit
Affidavit, my lord,
filed on?
this is filed on, my lord, 14 June 2024, my lord.
This is second.
The second affidavit filed by the finance department.
Okay, okay, not the previous one. Okay, the learned so and so submits that the matter may await the outcome of the decision of the high power committee. In view of the affidavit filed by the finance department. Okay, I don't know where it is anyways. Is it on record? Let me just see. I'm not seeing it here. The second affidavit. This is 23, this is 2023.
Well, this second affidavit is filed by one Sri Cho Akata Singhai Malay.
Yes, 19 June 2024.
Yes.
Okay. In view of the additional affidavit filed by the state respondents number 6 and 7.
But it's junior.
In matter be listed after
After 4 weeks, my lord.
4 weeks.
My lord, if this bench is not
Just
sitting on
before
a
the matter be listed, we may await for the decision of the high
High
power
power committee.
level committee. Matter be listed after 4 weeks. Yes.
Yes. Your lordship, in the next date, if this bench is not sitting, then it may take into the PC.
After 4 weeks on a date fixed by the registry. If this bench is not sitting on this fix on the listed date, the matter may be taken up through PC.
BC. Deeply applied.
All right.
My lord, here I'm for the sole respondent, my lord. I need 2 weeks time to file affidavit, my lord. Counter affidavit.
My lordship, I'm on behalf of the petitioner, SK Theory.
Mr. So-and-so appears on behalf of the petitioners, while Mr. So-and-so, learned counsel for respondents number,
Sole respondent.
or learned counsel for the sole respondent has prayed for further time to file their affidavit in opposition. In
2
view of the above, this after
2
weeks.
Thank you, obliged.
My lord, in this matter, CD was called for.
This is a bail application.
Bail application, yes.
Lordship, I have this.
302.
Yes, Lord. But apparently, Lordship, anyway, my lord, CD was called for.
Lordship, I have received a WT message stating that the eye of the case is in training with effect from 21/7/24 to 27/7/24 at NEFA, Shillong, Your Lordship. So if
So we'll wait for some more time.
yes,
This is 302 matter, so you cannot really rush. Someone must have died. Whether it's you or not, that's a different matter,
Yes,
but that person is involved.
Yes.
Okay. Heard Mr. Tofo, learned counsel for the applicant, along with Ms. T. Ginny, learned additional PP for the state respondent. It is seen that the case diary was called for in the previous court date, and the learned additional PP submits that the case diary cannot be produced today since the case IO is on training from 21/07/2024 to 27/07/2024. In view of the above, this is matter after 2 weeks.
no, Your Lordship, on 1st of
Okay, in view of the above.
First of August, Your Lordship.
This is matter on, we'll make it the week after that. We'll give you some more time. This is matter on 5th,
Maybe
Monday.
then 6th, Lordship.
6th,
Yes, 6th.
6/6/2024. Yes.
CD may be called for in that.
Replay. Meanwhile, CV is to be duly produced.
Obliged.
Yes, you had prayed for adjournment,
Yes,
isn't it?
yes.
What was the stage? I want to see the stage. Here. The respondents number 4 and 5.
Yes,
to
Lordship.
file their counter affidavit. What happened? Have you filed?
Not yet, Lordship.
I am for the respondent number 6. I have already filed.
6. So who has 4 and 5?
Lordship, I'm appearing for respondent number 4 and 5.
Oh, respondent? So you
Yes.
should be on this side. I thought you were the petitioner. Yes. Mr. So-and-so, learned counsel for the petitioner is present, along with Mr. Yes, 4 and 5? T. Tare, appearing on behalf of? Is your name here in the cause list? Or you're appearing on behalf of your senior? Okay. Mr. is present while Mr. So-and-so, learned counsel, appears on behalf of his senior, Mr. M. Doji, learned counsel for respondent number 4 and 5. Prayer is
Chip.
made for further time, who has prayed for further time to file their counter affidavit.
Lordship, I am for the respondent on 7. G there.
Yes, Mr. So-and-so appears on behalf of respondent number 7.
7.
Wow, what do you want? You want to file a counter also? You're not filing?
Moving forward.
Mr. So-and-so, learned counsel for respondent number 6 and 7. No, 7.
7.
7. Only 7.
Yes, Lordship.
7 has also prayed for time for filing of the counter affidavit.
Lordship, matter is pending for 2021, and they have been seeking for the time to file counter affidavit. On last occasion, only the Lordship, before your Lordship, only the matter was listed, and they have sought last time. And today again, they are. This may be the last chance.
No, that
Please.
simply, it's simply they should file their affidavits.
Especially for respondent number 4 and 5. They have been
Anyways, we'll
asking.
some more time now. In view of the above, Further time is granted to the respondents to file their counter affidavits.
1 week time may be granted.
After 4 weeks.
Lordship,
Make it- Or 3
letter is
weeks.
pending for
Yes,
2021,
it
Lordship.
is after 3 weeks.
Yes.
Deep knowledge.
Item number 4.
Yes.
Yes, what is this case
Yes.
about?
The impugned order which I have challenged is page number 33 of my writ petition. Based on the order passed by the ADC Itanagar, in case number DC oblique ICC oblique.
Okay, this is motion stage.
Motion, yes. 22/5/2024 SIB Itanagar versus Srimati Takam Aki. The EHC Itanagar is hereby directed to carry out eviction of the unauthorized structure of Srimati Takamaki from the public premises near SIB Police Chimpu.
So if you have your, if you are occupying the public premises, you have to vacate. You're saying you are occupying the public premises and you have been asked to vacate the public premises, is it? Then what's wrong?
We have, in the process of applying,
You are asked to vacate a certain a portion of land, which you have just read as okay, you're saying that this land belongs to you, is it?
Now,
What?
here in the
Establish
case,
your ownership,
I have applied for allotment of the land.
You have applied for allotment. Has it been allotted to you? No.
No.
So before allotment, you're occupying the land. If the land is not allotted to you, you can't occupy the land, isn't it?
I applied, but Mama, petition na. Book apply na petition. Book apply na.
Lordship, may I?
It appears from here that she has only applied.
Original order is at page 22. Original
Page?
order. Page 22. And
22.
Original. Petitioner has been heard properly along with the advocate lordship, counsel. Lordship. And then lordship, this is not just a premise. This is allotted to the SIB. The SIB is
Okay, the
SIB.
said land has been allotted to SIB.
SIB.
Ah.
It's Intelligence Bureau. It's
Ah.
Intelligence Bureau.
So if you are occupying the land which is already allotted to someone else, you'll have to evict.
No.
What is your case?
No, that I will come.
Hmm.
That I will come.
Hmm.
It was to initially 20,000 square meter was allotted to SIB. But 820 square meter was carved out by the government of Arunachal Pradesh from the allotment of the SIB. That is also in the report. Then, on the basis of the complaint of SIB, a case was heard. That is in Annexure 1, page 22. Page 22. This is the judgment order. But in the judgment order, they have said it that the land is, the SIB has got no authority because the SIB land was already been carved out.
So this order of the Deputy Commissioner dated 22/05/2024 says that the land occupied by the SIB does not belong to them, is it?
It does not belong to them.
Okay,
Yes.
but does it belong to you?
No. Come to the Paratu Pest School gate to near Bombila Hotel, Simple.
go for, and accordingly, the authority of SIB have paid land lease value for 30 years with effect from 12/7/2014 for land measuring 19,180 square meter amounting to rupees 1,91,800 through Treasury Salan number such and such, and the same is government land and not a part of the allotted area of SIB department. Now it is very clear. Now here in the
So it
order,
belongs to the government.
yeah. Now,
Not to you.
here in the case, in the judgment, is very much confusing. Further, page 22, 32. Further, the undersigned has no any authority, oblique jurisdiction regarding the compensation matter, and therefore, the respondent party may approach the competent authority accordingly, and also may approach competent authority for consideration of allotment application. As per this, as per order.
So who is the competent
Yeah,
authority?
as per order dated on 22/5/24. Now,
The government?
come to page 70. Page 70.
No.
This is a district land allotment revenue settlement officer. Government of Arunachal Pradesh. I have applied it in the year 31/3/2021, and in my application, it was written, verify the proposed plot and its feasibility. But now, though I have applied it, there was no verification, no feasibility is ascertained. Whether this land is for allotment, for feasibility, having feasibility or not, it was not ascertained. Then again, another order, on the basis of that order, Annex 17, page 77. On the basis of that order, I have written to the Deputy Commissioner, prayer for consideration of land allotment submitted by Srimati Takam Akil. Serial number also I have quoted 1352 as per APRL form number 46 on 19/2/2021. I have applied it, and on the basis of that allotment.
You have already applied, it's not given to you.
Allotment come after application. So I have applied. Without application, there will be no allotment. So matter is in this order, all these
You
orders-
applied, was it allotted to you? No.
And in the meantime, again, the Deputy Commissioner has issued an order, Annex 16, come to Annex 16, page 76. Page 76. Order dated on 21 June 2024. This is for the general information of all concerned that no new LPC and allotment application shall be entertained till further order. Further, new and all application for allotment shall be processed only after the finalization of the cadastral map, and new LPC application will be accepted after disposal of all the pending LPC files. Now, I have already applied, but again, that allotment has already been stopped. So when the allotment is
When you apply for allotment, it is not as if you have the right to be allotted. And the state government is taking steps to make sure that cadastral map is first made, and then only all the applications for allotment will be considered. So you cannot say you have to give me the land.
So my contention is that during this order,
Where is your right which has
enforcement
been?
of order dated 21 June 2024 issued by the Deputy Commissioner Capital Complex.
So do you have a right to come to this court under section?
I should not
56?
be evicted. I should not be evicted because I have applied. I have followed.
You
the
have
order.
applied, so you're occupying, but you have only applied. You have not been allotted, so you
Not
cannot
yet
apply.
allotted. But the allotment has been stopped by the order of this 21 June
Yes.
2024.
Allotment has been stopped, so you have not been allotted.
And I have everything since 2021.
But supposing your allotment is
Government
refused,
has not allotted. It is not because of me. It is because of the government. They should reject my application initially. They are not rejecting it. They said it is ascertain the feasibility of the land plot. So till today, they have not ascertained the feasibility of the very plot.
I don't think, just because you have been waiting for allotment
Yes, I am
and you have
waiting for.
not been allotted, you should have gone somewhere else. You're not being, the state government can refuse the allotment
And
also
during
of the
the
land.
pendency of my allotment process, how I will be evicted? This is my question.
Anyways, we'll issue notice. Let's see what is happening.
Lordship, he is having two tongue, Lordship, like, this in other.
His main,
other
his
than he's saying
main,
this
his
is
main
private land.
contention is that
No,
he had made this application. She has been waiting patiently either for her application to be rejected or accepted. Then while she was waiting in anticipation, this notification was made that nothing will further. So he feels that some of his rights or whatever has been. So let's see what is the government going to say.
No, Lordship, actually, if Lordship read all the judgment of the Lordship will come to know that not at all, this is not at all the fact. Lordship, the SIB, State Intelligence Bureau was allotted land 20,000 square meter, but then the government, when they asked them to
Anyway,
give
you
up
issue notice, you
No,
give a written reply and then we'll see.
yes, only notice may be issued.
Only
Otherwise,
notice.
Lordship, this is 820, Lordship. If Lordship see this just one sentence, Lordship. This 820 square meter is for widening of the road, the
So
commissioner
you
opposite
file
went to
your,
the
you
SIT.
file
That's
your
why-
this thing reply and
I
then
have
can be
applied-
disposed of in the next.
No, I have applied only for
with the
550
affidavit.
square meter.
Petitioner was a contractor of the road and he had engrossed this place, Lordship.
So you file it in a written form, then maybe in the
Yes,
next
Lordship.
admission hearing, it can be disposed of, but let the
Yes,
submissions be present, isn't it? It'll be better like that.
Lordship, and Lordship, no, Lordship.
We should notice first, okay? You file and then admission stage.
No, my lord, notice
This is the motion stage, so
notice that in the meantime,
It's
this
not
eviction
very
order
clear,
may be
That's not,
suspended.
no,
because
nothing
Lordship,
will be issued.
then I will
Yeah.
Lordship argue for
Yes,
the.
yes, nothing will be
yes.
filed.
Yes.
Heard because since the matter has not been, land has not been allotted, I don't think anything
is
is
allotted
required.
only.
So
It
we'll
will
see,
not be allotted,
that will be
Lordship.
disposed of, Heard Mr. So-and-so, Laureate Counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ slash order or direction to the respondents on the grounds that the petitioner has been evicted. No, has been issued an eviction order of her land and for construction of RCC building here. No, this is what, and the construction must be of RCC building here, SIB office, Chimpu, within brackets, Gopur, a close bracket, Tanili, comma, Itanagar, Papampure district, AP. Wide the impugned order dated 22/05/2024, passed by the office of the additional deputy commissioner, cum estate officer, comma, Itanagar Capital Complex, and order dated 08/07/2024, issued by the deputy commissioner, Capital Itanagar, directing the EAC to evict the petitioner from the land without considering the submissions of the petitioner made through her fresh petitions or without providing the petitioner an opportunity of fair hearing. Which is also a violation of the provisions of the Arunachal Pradesh Public Premises within brackets eviction of unauthorized occupants close bracket Act 203.
Lordship, here I would say that he has been heard properly by this order dated 22/5.
That
Petitioner
is supplement-
as well as the complainant SIV Lordship. They were present, the Lordship, their presence is also recorded in the order.
issue notice to the respondents, Ms. So-and-so accepts notice on behalf of the state respondents.
Yes.
No need to issue any formal notice. List after. Will you be ready? 2 weeks?
2 weeks is in.
List after 2 weeks. Yes.
Yeah.
May I please, Lordship? Lordship, I'm appearing on behalf of Mr. Yudeka, the panel counsel of the United India Insurance Company Limited. Lordship, the senior counsel is out of station.
Okay, where's the sole respondent?
Sole respondent.
Service report in respect of sole respondent not yet received.
Lordship, the step could not be taken till that. So some more time may be granted for taking fresh step.
Mr. So-and-so appears on behalf of his senior, Mr. U. Dika, learned counsel for the appellate, who is not able to appear since the learned counsel is said to be out of station. It is seen by the office note dated 24/07/2024 that service report in respect of sole respondent is not yet received. The learned counsel appearing on behalf of his senior, Mr. U. Deka, prays that they may be allowed to take fresh steps upon the sole respondent. Prays allowed. Necessary steps to be taken by the appellants. Yes, list after 3 weeks.
Thank you, my lord.
Yes. Service report.
Yep.
Yes.
Your lordship, in this matter, the
Notice is awaited.
yes, 4/3/24 on 4/3/24, respondent number 2 refused to receive the notice. 1 and 4 duly served, 3 and 5 awaited, your lordship.
Okay. Heard Mr. T. Ete, learned counsel for the learned
appellant.
additional PP for the, this is your appeal
Yes, state appellant. your lordship.
for the state appellants. It is seen that notice upon respondents number
3 and 5 awaited.
are still awaited. The learned no, this office notes
Yes, your lordship.
says that AD card is received in respect of respondents number 1 and 4.
Yes, that means copy served to 1 and 4 duly served.
Yes.
To respond number,
We'll wait for 3 and 5. Okay.
yes, your lordship, await
Copy
for
of
3
the
and 5.
above list after 3 weeks.
Yes, deeply obliged.
What happened? 13 or 14? Okay. File is not there, so we'll do 14th. Okay. None appeared for the parties on call. List after 3 weeks.
Item number 15.
I am for the respondent. On last appearance.
Yes.
My lord,
What is-
our reply is ready, my lord. We need 2 weeks time to file our affidavit.
Okay, Mr. So-and-so, learned counsel for the petitioner submits that they will be filing, submits that he may be granted further time to file their rejoinder affidavit.
My lord, there is another connected matter, CRP number 10.
Okay.
This matter will be listed along with that.
Mr. So-and-so, learned counsel for the respondent submits that there is a similar matter registered as what?
CRP number 10.
CRP number 10/2023, which is pending before this court. And prays that both the matters may be listed together. In view of the above, this is the matter after 3 weeks, wherein the mentioned CRP number 10/2023 is to be clubbed along with this case. Yes.
God bless.
Item number 13.
May I, my lord?
Yes.
My lord,
affidavit-
service have been completed, my lord. So matter may list for admission, my lord.
No, here. Who is appearing for respondent number 3 and 4?
They are private respondents, Lordship.
Vakalatnama not filed on behalf of respondent number 3 and 4. What admission? We have to finish the process first. Now, Mr. T. Lowang submits that he will be appearing on behalf of respondents number 3 and 4. And will be filing his Vakalatnama within a week. This is the previous order. So now the office note says that Vakalatnama has not been filed on behalf of respondents number 3 and 4. Who is Mr. T. Lowang? He's not here? Okay. Mr.
T. Darye.
T. Tari appears on behalf of the respondent along with Ms. So-and-so, learned government advocate for respondent number
1 and
2. It is
We have
seen
filed
that-
our affidavit.
Yes, 1 and 2. It is seen that though Mr. T. Awang, learned counsel, had submitted in the previous court date that he will be appearing for respondent number 3 and 4. Office note indicates that Vakalatnama has not been filed on behalf of respondent number 3 and 4. In view of the above, we may await for respondents number 3 and 4 to be duly represented, list after 3 weeks.
3 weeks. Okay.
Item number 15.
My lord, although fresh steps were taken, the service is still awaited on the sole response.
Okay. Mr. So-and-so, learned counsel for the petitioner is present. We will await for a return of service report in respect of the respondents.
So
Yes, in respect of the sole respondent. Okay, against the sole respondent. List after 3 weeks.
my lord, there's an interim order, my lord, and that may be extended.
Interim order passed earlier shall continue till the next returnable date.
All right.
Item number 17 and 18.
Yes, what is this I about?
May I please, my lord? My lord, I am for respondent 16 and 17.
And for respondent number 2?
Yes, so are you going to file a written objection?
Yes, my lord, I will file my written objection and we need some time, my lord.
Okay. Miss
8 along,
Learned Counsel for respondents number
16 and 17.
16 and 17. What about the others?
And for respondent number 2?
Are you going to file?
We have not yet received a copy of.
Okay. Okay, Miss So-and-so, Learned Counsel for respondent number 16 and 17 has prayed for further time to file the written objection, while Miss So-and-so, appearing on behalf of respondent number 2, submits that they have not received copy of the IE application. Okay. In view of the above, the Learned Counsel for the applicant is to take necessary steps by furnishing copies of the instant IA to the respondents, to the Learned Counsel for respondent number 2. Yes.
3 and 6 also. I know that receiving copy. I for respondent number 3 and 6.
Okay. And to the Learned Counsel for Mr. So-and-so, Learned Counsel for respondent number 3 and 6, who also submits that copies have not been furnished to him. Yes, in view of the above, list after 3 weeks.
3 weeks.
Anything else? What have you want a name to be reflected? Okay.
I'm for this phone number.
What? Anything you're going?
Obliged, man.
As per the order dated on 15/5/2024, the lower court record was called for, but it was not received. We were waited for the lower court record. In the meantime, we were asked to file the affidavit, if any. It was a liberty given to the parties.
May I, Lordship? I'm appearing on behalf of this Apex Customary Court. I just brought this lower court record along with me.
What?
Customary court record.
Okay, you file it in the form of affidavit.
Okay, fixed date.
Yes.
Date may be fixed.
Mr. So-and-so, Learned Counsel for the petitioner is present along with Mr.
Keeper.
But Learned Counsel for respondent number
1.
1.
And your Lordship, I am for respondent number 2.
And Mr. So-and-so, Learned Counsel for respondent number 2. The Learned Counsel for respondent number 1 has prayed for time for bringing on record what were you supposed to submit? Bringing on record the Yayan appeal, is it?
Yes, nearly appeal.
Bringing on record the copy of the Yayan appeal number 01/2023 by way of an affidavit. Yes. Then anything else in view of the above, list the matter after 3 weeks.
Date may be fixed,
Or-
particular date, specific date.
Give a date. When do you want it?
5th of August or
Okay, in view of the above, list on 5/8/2024. Yes.
highly August.
Service copy is still awaited. I'm sorry, service report is still awaited, Your Lordship.
Ms. So-and-so for Learned Counsel for the petitioner is present. It is seen that the service report upon the respondents is still awaited. In view of
And the
above-
interim order may be continued.
In view of the above, list after 3 weeks. Meanwhile, interim order passed earlier shall continue till the next date of listing.
Okay.
Your Lordship, I'm from the sole respondent.
For the petitioner.
I have filed for the affidavit in reply and the service copy has been
Okay, so you want to pray for time? Miss So-and-so, learned counsel for the petitioner is present along with Mr. So-and-so. Learned counsel for the sole respondent. The learned counsel for the respondent has prayed for further time to file the counter affidavit. In view of the above, list after 3 weeks.
Hello, there is an interim that may be continued.
There's interim order.
Yes, sir.
Meanwhile, the interim order passed earlier shall continue till the next returnable date. Yes. Yes, what is this about?
Here, Your Honor, we have to file a rejoinder.
Mr. So-and-so, learned counsel for the petitioner has prayed for further time to file the rejoinder affidavit.
Interim may be continued, Lordship. There
In
is
view
need.
of the above, list after 3 weeks, interim order passed earlier shall continue till the next date of list.
Obliged, Lordship.
My please, Lordship, this is application number 482 for quashing of the judgment, This is a post-conviction, application. Post-conviction, they have come into settlement. This is a 380 case, when the person from whom things have been stolen, when she has forgiven, Lordship, and the.
So he's been convicted.
Yes, Lordship.
Is there an appeal against the conviction?
Yes, conviction appeal is already pending.
Okay, so appeal is pending before the Sessions Court.
Yes. So in the
Who
last.
has filed the appeal? You have filed the appeal
Yes,
because you
yes,
were convicted.
yes.
For how long? How many?
Convicted-
Terms of sentence?
The terms of sentence is, Lordship will kindly see that judgment for period of 3 years with fine of 15,000. Page 30, Lordship. The 29 and 30, last paragraph. Both the section 380 and 457. So this naturally, it's not a heinous offense, Lordship. Then definitely this honorable court 482 can quash even after conviction. Several judgments are there post conviction also. This honorable court can exercise powers under 482, Lordship. I need not, Lordship, bother your Lordship with all those judgments, but we had in the last time, Lordship, we had already submitted the judgments also. I don't know, it's record is there, Lordship.
And was it heard? Was the matter heard?
Yes.
Matter was heard
Mm,
in the last court date? No.
No, it was not heard, but we had submitted the judgments because there was a bit confusion regarding can the 482 can be exercised as post conviction and or not. That was the,
These are the judgments.
yes, yes.
What
Post
does it
conviction
say?
also.
I have not really.
Post conviction also, this honorable court, the first which we have submitted is 2000 Supreme 1356. This is Vachitra Singh was petition versus State of Haryana and another. It's a para 7 we have referred to. If lost,
2017. Okay.
yes, Lordship got that one.
Yes.
Yes.
Para
Para
seven.
7, Lordship. As per the division bench judgments in such and such and another versus such and such, another one such and such, it is held by this court that the compounding offense that the appellate stage is permissible on basis of compromise invoking the powers under section 482 CRPC even after conviction by accused person by the trial court and during the pendency of appeal against such conviction. Following questions were framed for consideration. All those things were considered. Then it was.
What are those things? Let's see.
Yes, yes. Whether the power accessible by this High Court under section 482 is controlled by section 3, of course, this is definitely not controllable, Lordship. Whether criminal proceeding can be quashed by the High Court and exercise powers under section 482 CRP, even after accused was found guilty and convicted by the trial court, though the matter is subject before the appellate court. So,
So we are concerned with the
Second,
second point. huh?
yes, yes.
So where's the second point decided?
Yeah.
Para?
16 lordship.
Para
As
16,
regards
yes. huh,
explain single judge whether the inherent power, lordship got last para.
Yes.
Inherent power under section 480 is to quash criminal proceeding on the basis of compromise entered between the parties can be invoked even if the accused has been guilty and convicted by the trial court. We find that in Dr. Arvind Borusal, etc., versus State Madhya Pradesh and others, this is reported. The unfortunate matrimonial dispute was settled after appellate husband has been convicted under section 498A.
This is
sentenced to
concerning a
15
matrimonial dispute.
No, but
Here. in
the
this case.
question was whether post conviction also for 482 can be exercised.
Okay, anyway, just continue.
Yes,
continue
Lordship,
reading.
yes. For it, IPC sentenced to 18 months
Well,
imprisonment and
These are
he's-
examples from where 482 was invoked. Okay,
Yes.
so one is the matrimonial dispute, huh?
yes, no, so I will just.
Anything else? Yes, please continue.
18 months imprisonment and his appeal was pending before the first appellate court. The appellate court quashed the criminal proceeding keeping with the peculiar facts and circumstances case and in the
Keeping
interest
in
of
view
justice.
the
Also, the
peculiar facts and
Yes.
circumstances of the case.
Continuation of criminal proceedings would be an abuse of processor and also by invoking its power under Article 142 of the Constitution. Since the High Court does not possess any power akin to one under Article 140 Constitution, the cited decision cannot be construed to have vested a high power with such like unparalleled. The magnitude of inherent jurisdiction exercised by High Court under 482 CRP would be to prevent abuse of law or security and justice. However, is wide enough to include its power to quash proceeding in relation not only to the non-compatible offence notwithstanding the bar under section 320, but such power in our considered view is accessible by any state, save that there is no express bar in invoking of such power is fully justified on facts and circumstances of the case.
Yes, but
So-
looking on the circumstances of the
so-
case,
yes.
facts of the case.
Yes.
So this
Lordship-
example which you have cited
Yes.
is concerning an incident where it is a matrimonial dispute.
Yeah, of
Okay,
course.
husband and wife have come to a settlement.
Yes, but the
Okay.
moot question is whether after conviction, my lord, 482 can be
No, It
invoked.
can be.
Yes, it
If
can
you
be.
look into the facts and circumstances
yes,
of the
yes.
case. So your case is what?
So this is a, my lord, not
It can
matrimonial,
be,
it's a theft,
yeah.
no, theft in a dwelling house, 380, lordship.
So theft,
Yes, theft, my lord,
theft is an offense against the society. isn't it?
lordship, individual lordship, when it's against the person from whom it was stolen has now, my lord, settled the matter and she's pardoned him. And of course, the lordship is aware, my lord, there's a saying where every saint has his past and every sinner has his future, lordship. The accused is 24 years of age, my lord. He has a long life to go, my lord.
Please,
Seeing all those are.
Anyways, you have enclosed about 3 judgments.
Yes,
Okay, now this one is given example where the facts of the case are such that it is a dispute, matrimonial dispute. Okay?
Yes.
Now the other case, this is concerning
this is next is
under
lordship.
section.
108 days is not condemned by this honorable court. This will be amount to buried by the justice, buried in the justice, because we have a good reason to appeal against the KEBA decision wherein the execution was done. Therefore, my submission is that this need to be heard in the merit.
Merits,
Until and unless if the condemnation of 108 days is not condemned by this honorable court, this will be amount to close forever. Thereby, we shall face the irreparable loss because the matter pertaining to the dispute is pertaining to the land dispute measuring about more than 3 puras. Therefore, my lord, this deserve to be condoned and I am praying for the condon. And so far the principle, so far the cardinal principle in respect of the condonation is concerned, the Supreme Court is also in favor that
Give me the.
yeah,
this
even
authority.
if the condonation is not filed in the application form also, if the court found that there is a sufficient cause explained, then that can be condoned. And my submission is that I have the sufficient cause, my lord. But despite of my lord, this voluminous, this is in the page number 47 only, which is my lord indicating that even without filing the format application also, if court found that there is a sufficient cause, this should be condoned. Is that I have the sufficient cause
Yes,
to
so
be
he is
condoned by
relying
this.
on the judgment
and-
of the apex court.
Right.
Okay.
So this should be heard in the, this should be, I should be allowed to heard in the merit of the case, my lord.
Yes,
That must, my lord.
yes.
Regarding the explanation of delay between 35/2022 to August 2022, it's not acceptable because, my lord, kindly see the order, my lord. Order dated 35/2023,
Page
page 10 in
10 of
IA,
the,
in condemnation application.
okay,
My lord, relevant portion,
yes.
page number 11, last paragraph. May I read, my lord?
Hmm.
After hearing the parties on careful perusal and verification of the material available on record, the execution petition is disposed of and the judgment pronounced in open court under seal and signature on 30th day of May 2023. My lord, on that day, judgment was pronounced on 30 May 2023. However, they made amendment in their application that the Deputy Commissioner had issued the order, had not issued the order till August 2023. This is a post statement. The parties were present in the on 30 May 2023, and judgment was pronounced in presence of the parties. So there is no question of issuing the order by the Deputy Commissioner till August 2023. My explanation of 35/2022 to August 2023 is not acceptable at all. Because this statement, the statement in the paragraph 8 is false.
No, concerning, you see, I heard both the parties in detail, whether it was heard on that same day itself.
Yes, madam, on same day.
Yes.
Now, madam, they stated that the Deputy Commissioner had not issued the order till August 2023. Because order was pronounced on 30 May 2023.
So the delay is explained from 30 May 2023, isn't it?
Yes, August 2023 is not acceptable. Because their statement is false. Because judgment was pronounced in open court.
See, if the judgment is pronounced on 30/05/2023, okay? And the appeal, is it? Is this an appeal?
Revision, ma'am, civil
Okay, and the revision petition was filed on
14/12.
14/12/2023.
12/23.
2023. So the delay,
So the my lord limitation period is starting,
oh, yes.
3 months.
So after the reduction of the limitation period, the actual limit, number of days is 108. This is after the deduction, isn't it? Yes. Hmm.
And
So
my-
what is your point here?
Apart from that also,
Huh.
other grounds of
He's not counting the limitation period from the month of August, he's counting it from May. He's counting the limitation period from, he's counting the limitation from the date that is 35/2023. Okay, till the date of filing and then reduce the limitation period. So it's okay whether he knew or what, that's a different matter, huh? Then
my lord, in that case also, my lord, limitation period start on 29 August.
29th August.
29 August.
May, June, July, okay, 29th August. So the number of days will be how much? Is it calculated wrongly? Yes, 29th August, so it's correct. From 29th August.
Yes.
So that's a submission from 29th August to 14/12/2023.
Regarding my lord, this 29 and 30 August, there is no, their explanation is incorrect. And others from my.
Why is it incorrect?
Yes, my lord. Because my lord, they stated that the deputy commissioner had not issued the order till August.
See, whether the deputy commissioner issues the this thing on August or not, that's a different matter. Okay, that's one of your points. Okay, fine,
And my lord, other ground there in which on which they sought condonation is not sufficient for condone the delay. My lord, this is my submission. On that ground, my lord, this application may be dismissed.
Yes. Yes.
Yes, certain clarification pertaining to the, my lord. That was the 31st May was the past day, my lord. We appeared before the deputy commissioner, we admitted. And my lord, on that day, my lord, that judgment was passed in the open court, but no written judgment was there, my lord. So that I accepted. And at the same time, my lord, there is a misconception from the respondent, my lord. I have not claimed even that my contention is that till 21st August 23, we have received the this judgment copy. But even then also, my lord, I have never claimed to that benefit. I frankly admitted, I honestly admitted that since
From
the
30, you're counting the
yes.
limitation from 35, isn't
Yes.
it? So it's okay.
Yes. Therefore, my lord,
Yes. I'll pass the order later, but this thing is condoned, okay? Limitation, delay of 108 days is condoned. I'll give the details later. Now, in the main civil revision petitions, on the disposal of IA 210 within brackets AP 2023, condoning the delay of 108 days. Heard, Mr. So-and-so.
Modi.
Yes, learned counsel for the petitioner. The instant civil revision petition is filed under under Article 227 of the Constitution of India, read with Section 115 of the Civil Procedure Code, 1908, for quashing the order date, for quashing the judgment. It should be judgment, not order and judgment. The judgment and order dated 30/05/2023, passed by the learned court of Deputy Commissioner, Yangkyong, Upper Siang District, AP, in connection with execution petition number 1/2022-2023/248. Full stop. Issue notice to the respondents. Mr. So-and-so, learned counsel accepts notice on behalf of the respondents. Requisite copy of the instant civil revision petition to be duly furnished to the learned counsel for the respondents. List after 3 weeks.
3 weeks.
For submission of counter affidavit, if any.
Till and my lord, the operation of the impugn order be stayed, my lord, because pertaining to this is land dispute and then now this assessment is going on. So if
In
it
the
is not
meantime-
stayed,
My lord,
there will be.
I am objection.
Okay,
My lord, this.
the prayer for interim stay or the prayer for an interim order for stay of the operation of the impugned order will be considered in the next date of listing.
All right.
Yes. This is the last item, is it, for
Yes.
today?
Your lordship will remember this is a case where I have put my objection on maintainability with regard
Okay.
to compounding of offense, your lordship. The
Oh, yes, yes.
The unfortunate that has happened is that your lordship
We
has
had
called for the
CD.
CD, your
Yes.
lordship. We had in fact received on 2/5/2024 and the matter was actually handled by my colleague El Hage. She did not, she might have not seen the WT message at that point of time. The matter has already been charge sheeted in 26/11/2021, your lordship. After that, your lordship, we had again sent a
What happened? What happened to the, okay,
the CD has already been the matter has already been charge sheeted, your lordship.
okay, it's been.
Your lordship,
Yes.
yes, your lordship will also see in the petition.
Yes,
which,
it's
the
there in
court's-
petition also.
The course title, a reference has been made that the matter has already been charge sheeted on
Okay.
26/11/2021.
So the matter has already been charge sheeted. That obviously means that the file is available. Charge sheeted before which
Yes,
court?
lordship, in this regard,
Ah.
charge sheeted before this chief judicial magistrate.
Ah.
Yes, now the question is that for last 3 years, this petitioner number 2 has been approaching the GR branch and the office of this chief judicial magistrate UPA, applying CTC for this charge sheet. But according to GR branch, charge sheet is not available
Your
as per the record.
I'll-
So, and same thing, this person has approached many times for last 3 years to police station, since he has to avail the NOC from the police station to apply for his employment.
So you will this thing pass an order for the matter to be considered expeditiously before
Yes.
the concerned court, isn't it?
Yes.
320, because these are all compoundable offenses.
Yes,
So,
lordship,
in fact, it doesn't have to be compounded by the magistrate itself.
since lordship, it's compoundable, but its file is not available. Once file is available, then also there is a process. There is a process, this chief judicial magistrate will take cognizance and there might be alteration of section also. Now, here, lordship, I had already apprised this high court judgment, some of the high court judgment where same cases has been quashed by,
Let's see,
yes. So,
all compoundable offenses?
yes, by Himachal Pradesh High Court bench. So that I'm just
See, compoundable offenses should be accepted straight, but then again, it depends on the section, the victim
Yes.
also we have to see.
same section. That's Krishnu at
Let's see.
Christian Chan. So section of 323, 500, 341, 504, 506. So in the instant case. Six. Yeah.
All compoundable?
Yes, all compoundable. And there is same parallel practice in Gujarat High Court also. Yeah. I will give you that. Okay. And even from Gujarat High Court also, there are 5 cases. And based on this BS Joshi case, because 320 is for compoundable cases, but it's about not about compounding the case, it's about quashing the proceeding and the FIR. So there is a difference between quashing and the compounding of the case. So in the instant case, this petitioner, they approach their GR branch many times, that record is not available, even in the police station also. So that's the lordship.
If I may, your lordship, the citation produced, if your learned counsel does not mislead
So
the court, your
it's
lordship,
the report.
there is one section which is not compoundable, your lordship.
Hmm.
There is
Yes,
section,
just find out. I'm just having my.
323, 500, 341, 504, 506. And again, I will apprise more judgment.
Yes, anyways, see,
Yes.
because when they compound the offense.
And even they've settled down.
482 is invoked when, in spite of there being a 322 provision, 320 provision.
Yes.
Okay, this court in non-compoundable offenses can also invoke section 482. That is
Yes.
what the issue is usually is about.
Yes.
Now, you have approached this court when all the offenses are compoundable.
Yes.
The 320. So in spite of there being a 320 provision.
Yes.
Okay, under 482, this court can invoke its an inherent power.
Yes, lordship.
Okay, and compound offenses, except the compounding of offenses which are non-compoundable. That is the whole issue.
yes.
Yes.
Now, you have come to this court for all compoundable offenses
Yes,
where
lordship.
it can be and the law says that for compoundable offenses, the concerned court can accept the compounding. Sometimes the nature of the offense is such that the victims are also called to ascertain whether they are actually compounding the offense and then acquit the person. Okay, no cases ended. So now your submission is that in cases where all the offenses are also compoundable, the High Court has also exercised its jurisdiction, invoked its inherent power under 482.
Yes.
So it's only on that point that we want to see.
Yeah, yes, lordship.
So you're come with a judgment where the cases 323, if it's of simple distinct nature, it is compoundable. What is 500? Is it compoundable? Just see.
Yes.
Your lordship, if I may, your lordship, like to
Yes.
interfere, your lordship.
Uh,
Your lordship
And there are
will
more judgment from
Wait, wait,
Your
different.
lordship will also see that BS Joshi case that they have relied upon.
Yes.
One of the section was non-compoundable.
One of the sections is not compoundable.
And the issue with regard to that was 329
Huh.
bars. There was a bar on the for compounding of non-compounded offenses. That was discussed in BS Joshi case.
Non-compoundable cases can be compounded. That's the main thing. Okay, now
Yeah.
the
Now-
issue here is all compoundable
All compoundable.
offenses. So give me a judgment
Now-
where the High Court
now-
has invoked its power.
I already
Also-
just
also
served.
to further-
To
further my submission-
Homework, find
To
out.
further my submission, your lordship. This side, if you my learned colleague shows
Yes,
that
yes, the
after
one-
conviction, even in compoundable cases, the parties has not come for a compromise during the trial, leading to conviction. Now, after conviction,
That
that-
issue has already
that
been,
under
judgments are
482,
there,
yes.
That's not the issue here.
yes,
The issue here is where the offenses are all compoundable.
yes,
Okay,
Yes,
yes.
yes.
then should the petitioner approach this court under
482.
482?
Yes.
Okay, 482, they approach when the offenses non-compoundable are again squashed. Okay?
Yes, that's for
So
question.
now you have come up with a judgment.
Yes.
Okay, now in this judgment, see if the offenses are all compoundable. That's
All,
the only
all
thing.
compoundable, lordship.
Just check. Do your homework.
There are more judgment from Gujarat High Court and Himachal only. Since both party has already settled. So that's
500, 341, 504, 506. See if they all are compoundable.
Yes, Lordship.
Is it?
Yes, Lordship.
Okay, give me one more judgment where all the offences are compoundable. Otherwise, this court, why should it trouble itself with compoundable cases? It's for the trial court to take up those matters. That's the main issue. If the litigants start approaching this court for compoundable offences also, but if
Yes, it-
the other high court benches have also considered such applications, then
This one, this one. More.
I am not
Yes.
too disinclined to agree also.
Two.
323, 341, 504, 506. Let me see.
And subsequent that next Ramesh Kumar one is
Let me
323
see.
341 506, almost akin to this case.
Yes, let me see for myself since. Okay. 320. Look at 320. From the person whom the hurt is caused. 341. Confinement, the person who was restrained. 504. Person insulted. Okay. 506. Person intimidated. And 34. All the offences are compoundable.
Yes, ratio has not been decided, Your Lordship.
Okay.
Your Lordship will see this is the High Court
So
judgments, Your Lordship. I'll
that's
just-
based on all
My
has
learned
proceeding
friend,
has
at
been
least
twice
let
because
me
that has
speak
been
and make it clear to the court. I have,
Yes.
V.S. Joshi has on many occasions been decided
Okay.
by the High Court, by the Apex Court, Your Lordship.
Let's
One,
see.
one of the major decision was also in the case of Gyan Singh, Your Lordship.
Yes.
Your Lordship, if I may take Your Lordship to paragraph 2, which is at page number 4. Down below is the page number, Your Lordship.
Page?
Page 4,
Para?
para 2, Your Lordship. I'll just show. This is how the matters have come up for consideration before us. Two provision of the code which are vital for consideration of issues referred to larger bench are section 320, 482. Section 320 of the code provides for compounding of certain
Compoundable
offenses.
offences, yes.
So yes, now next page, paragraph 5, B.S. Joshi has been interpreted, Your Lordship. Now, if I may take Your Lordship directly to page number 22, Your Lordship.
Yes. Para 22 or page?
Page 22, para 47, Your Lordship.
Let's see, para 47. Yes.
If I may, Your Lordship. Section 320 of the code articulates public policy with regard to the compounding of offences. It catalogs the offence punishable under IPC, which may be compounded by the parties without the permission of the court, and the composition of certain offence with the permission of the court. The offence punishable under special statute are not covered by Section 320. When an offence is compoundable under Section 320, abatement of such offence or an attempt to commit such offence or where the accused is liable under Section 34 or 149 of the IPC can also be compounded in the same manner. A person who is under 18 years of age or is an idiot or a lunatic is not competent to contract compounding of the offence, but the same can be done in same can be done on his behalf by the permission of the court. If a person is otherwise competent to compound an offence is dead, his legal representative may also compound the offence with the permission of the court. Where the accused has been committed for trial or he has been convicted and the appeal is pending, composition can only be done with the leave of the court to which he has been committed or with the leave of the appeal court as the case may be. The revision court is also competent to allow any person to compound any offence who is competent to compound. The consequence of composition of an offence is acquittal of the accused. Subsection 9 of 320 mandates that no offence shall be compounded except as provided by this section. Obviously, in this manner thereof, the composition of an offence has to be accorded with section 320 and in no other manners. Your Lordship will see, even in this, while trial, while appeal, while revision, the court can compound. But there is a proviso under subsection 9 which says the case can be compounded only under the section 320, Your Lordship, as provided under 320 and in no other manners. Now, next paragraph is, the question is with regard to inherent power of the High Court in quashing the criminal proceeding against an offender who has settled his dispute with the victim of the crime, but the crime in which he is alleged involved is not compoundable under section 320.
This is
This is the-
concerning not compoundable.
Yes, not
Okay.
compounded. Now, next paragraph, Your Lordship will
No.
see. Section 482, as its language suggests, I'll just read the third last line in paragraph 49, Your Lordship. It starts with, it is equally well settled that the power is not to be resorted to if there is a specific provision in the code for redressal of the grievance of an aggrieved person. It should be exercised very sparingly and it should not be exercised against express bar of law and grafted in any other provision of the code. So the bar in under 329 is that if a case is compoundable, it has to be compounded as per given.
Yes, there is
Provision.
there is a provision of
Yes.
law where you can approach
Now-
the
now-
concerned court. Okay.
Yes.
So now you are saying that you had approached the concerned court,
Yes,
but you have, now where is that?
You know,
that's fine, Lordship.
You have to prove, you have to show
Yes.
convince this court that you are having difficulty
Yes,
approaching the concerned court and you are compelled to approach this court, though there is a gate open
Lordship.
for you before the
okay.
competent court, huh? Where's that?
Actually, there was
Where's the
only one
document?
question
Uh,
that whether compoundable cases should be quashed before this, under this 480.
Yes.
That was the
When
only
there is
question.
already
So,
a
yes.
provision of law, if
Yes.
this court also takes up all compoundable offences. Okay.
Lordship, here, let me, things that the instant petitioner and the FIR is, fact of the case is that that's false FIR. And in that regard, that's there in mutual settlement deed also. Since this victim, he himself is the informant and he has a illicit relationship with the wife of the petitioner number 1. And there was a family discussion, and for that family discussion, they gather at their own residence. That's nearby 10 or 20 meters.
It's concerning the compounding of the offence, huh? So
So that's why, in this regard, I already apprised this court that the BS Joshi, where means it doesn't, 320 doesn't limit 482. It's there in paragraph 15. BS Joshi and others, BS Joshi and others. Before that, there might be,
B.S. Joshi, Your Lordship.
what are you
Speak.
talking about, huh?
yes,
I have
in
the
BS Joshi, in paragraph 15, it's,
Paragraph 15.
yes, 1-5.
We hold that the High Court, in exercise of its inherent power, can quash criminal proceedings or FIR or complaint, and section 320, that is compoundable offences.
Yeah,
Of the court does not limit. So this court can exercise its inherent power and compound offences.
Yes.
Which are not
Not
mentioned under 320, isn't it? Does
Y-
not limit, 320 does not limit the power of the High Court
yes,
to compound offences which are not compoundable under 320.
yes, Lordship.
But our issue is different. Our
So,
issue
so
is
in,
when all the offences are compoundable.
In
and
fact,
Lordship
Your
here,
submission is only that the other high courts.
Yes.
okay, have also compounded, allowed quashing of the proceedings where the offences are all compoundable. That is the main, your submission.
yes, Lordship, and even this petitioner is being, student, he has to appear for many exam, and most of the time he has to apply NOC from police station for last 3 years. So that's the reason we moved here before this
Your Lordship,
honorable court.
Lordship,
So for the quashing of this,
if I may, Your Lordship,
Is that in your submission?
if I may, Your Lordship.
and
No,
Lordship,
But let me
even,
see if he has been having a problem
Yes, Your
for
Lordship
the
will,
last 3 years.
Your Lordship will see the allegation that they have made, they have
arrests
been
and
making
everything
before
were
the
made
court
in,
of the lower court, Your Lordship. Your Lordship will see they have written the GR number 187 of 2021. They have also written the date of the charge sheet and charge sheet number 26/11/2021. However, if they have approached the trial court in any manner by applying a certified copy, where is the copy of the certified copy annex here in Your Lordship?
So that's
If
why,
any
Lordship.
approach has been made to the police to for non-objection, where is the document
Lordship,
showing that they have approached? Your
That's the main point, that charge sheet is not available before the GR branch, and it's upstairs of this building only, GR
the-
branches.
in
And
the-
even in police station, the charge sheet is not there, but charge sheet number is there.
Where's this place? This place is at?
Bandadeva, it's 20
The trial is
kilometers.
pending before the
And
Honorable UPA court, Your Lordship.
UPA code is upstairs of this building
Upstairs.
Oh,
only.
UPA.
Yes,
Yes.
Lordship, that's
Therefore,
why
I'm saying that-
file is not available, so
Therefore, I'm saying
file-
that if they have applied for a certified copy, at least annex one to show the court that they
No,
have
if
approached.
it's before the UPA court, which is just here, then if file is not required, you file an application, a submission or a petition for the court to compound the offenses, which are all compoundable. What steps
Yes,
have you been
yes.
taken?
That's why,
Huh.
to file that application, there is a process before the Chief Judicial Magistrate by, we need that charge sheet, and there will be a consideration of charge sheet. And after the consideration of charge sheet, there might be alteration of section. So that's
Not the procedure, that is for CC. Okay,
That's why- that's
consideration
why.
of Charge, no, consideration of charge is not required.
Yes.
When, consideration of charge, etc. takes place when the parties have not compounded the offense.
Yes.
But at any stage, okay, when the parties have compounded the offense, you approach the court who is going to take up the matter. That consideration of charge is not required. We have already compounded the offense.
Even the notice.
Lordship, that will again same thing, abuse of process, because it's been 6 sitting, and for last 3 years, he has been approached. Since they have entered compromise
Why
with
are
him.
you so scared to approach? I have a
Okay,
feeling that.
very
Lordship,
technical.
may I suggest and pray
Ah.
that since the file is not available there, because
How-
even if suppose this court call for case diary or charge sheet from this GR branch, that will be the best,
No,
because
no,
that
Your
will help me to get the file.
Are we even,
Since
can
it's-
this honorable court
it's been
entertain
6
something indirectly that they can directly approach to your lordship? It's a very, I'm
Yes,
amazed
no,
how
we
they are.
will- We will pass an order
Uh,
that the trial court, okay, this is dismissed with a direction that you approach the learned, which court?
My lordship, then
They will see.
there might be, since it's a process, so
What
since
process?
both party has settled their
Wait.
dispute,
Heard, Mr. So-and-so,
and same will be
Learned
listed for
counsel
next lok adalat.
learned counsel for the petitioner. What, Lok Adalat?
Yes,
You want it to be sent to Lok Adalat?
yes,
Your
that will be the best,
Your
because
lordship, your
otherwise we have to file compound application before the
Let-
chief
let-
judicial magistrate, and they have to call again the case diary. That will be the
No, no,
process, lordship.
Let's see. Okay, heard Mr. So-and-so, learned counsel for the petitioner, along with Ms. So-and-so, learned additional PP for the state respondents. The instant the petition is filed under, for this court to invoke its inherent power under section 482 CRPC for quashing of the criminal criminal proceedings here mentioned pending before the learned chief judicial magistrate, capital complex, UPI district. No, UPI district, Papum Pare. On the basis of the mutual settlement deed executed by both the parties dated 06/02/2023. The learned counsel for the petitioner submits that the petitioner was charged under section 506/, under section 323/4 342/506/4 341/34 IPC in GR number 187/2021. And here you have already mentioned that he was charge sheeted.
Yes.
Then why
that
you
we
going for the
applied that
CJM?
charge sheet before the GR branch and before the CGM also, but
Yes.
file is not available.
I'm calling for the CD.
Yes, I'll just make a
Uh,
small.
So that's why file
request.
is not available.
I'll
We
just make
approached for last 3 years.
I'll just make a small
Until unless
request.
without file, we cannot file
I'll
compound
just make a
application
small
also.
request, Your Lordship, if my learned friends allows me, Your Lordship. First of all, this case is being dismissed on non-maintainable, Your Lordship. In that case, even otherwise, Your Lordship is passing an order for calling of the record for directing the applicant to approach before the trial court, Your Lordship. The case is pending before the CGM court, Your Lordship. They can also file their application. We have compounded the matter. Let this matter be brought before the Lok
That's what we
Lok
have heard.
Adalat.
That's what we have heard.
Yeah, that's the
Anyway,
same thing I'm
I've
saying.
heard your submissions, sir. Praying for a quashing of the charge sheet number 51/2021 dated 26/11/2021. And the consequential proceedings arising arising out of the said case pending before the learned Chief Judicial Magistrate. It is seen the facts of the case leading to the instant petition is that an FIR was registered by the instant petitioner number 1, is it, or 2?
Lordship,
The FIR was registered by
by
the,
petitioner number 3,
okay, by the instant petitioner.
all other petitioner
Number 3
against petition number 1 and 2.
against the petitioners number 1 and 2. Where's the FIR? Is it here? No.
FIR is here in page number 15, 15.
The original is at 17 page.
Original is in 17. So even in FIR also, if you see this, he is alleging for this kidnapping and everything, but he himself going to back to this police station by submitting this application just to mitigate the allegation that illicit relationship with the wife of this petition number 1. And the same, this there is a trial going on before this session court under 376 against this informant. And it's there in evidence stage.
No, so the informant, that is the instant petitioner, is also having a 376 case
Yes,
pending before him.
yes. And the order is with me that they approach this session court by stating that we compounded, but the section is non-compoundable. So that order is also,
Making the issue even more complicated.
Yes.
no,
This is, so how can you compound a 376 case which is
no,
already
here,
contained?
here in this case, this is not about 376 case.
Oh.
Here, actually, this case is being lodged by informant, this victim, just to weaken this 376 case against him, being lodged by the wife of this petitioner number 1.
Anyways, okay, whatever, I'll pass the order later, okay?
So,
Heard so and so, and so and so. Okay, and the order will be out by this evening.
Lordship, all this referred judgment may be
Yes, yes.
noted down. Highly obliged, Lordship.
The only issue right now is since some high court judges have also considered the matter, where all the matters are compoundable, whether it would be appropriate for this court also to allow the instant petition.
Yes, Your Lordship, even the
You
facts,
have a clear alternative
fact-
venue.
the facts and circumstances otherwise in this matter is totally different and deeply.
Yes.